Welcome back, sir. Let us start with the next chapter of the Indian Contract Act. Previous exam question papers on the offer and acceptance, sir. So, first question. Yeah. A shopkeeper displayed a pair of dress in the showroom and price tag of 2000 was attached to the dress. Till now, let us try to understand what he is saying, beta. So, shop is there. What is it, beta? Shop. So in the shop, what is happening? A shopkeeper displayed a pair of dress in the showroom. Shopkeeper is displaying the address in the showroom. This is a dress displayed in the showroom. Beta, does it mean it is an offer? Answer is no. है ना? A shopkeeper displayed a pair of dress in the showroom and price tag is attached to 2000 rupees. Price tag is there, beta, for this. Price is 2000 rupees as a price tag. Miss Lovely looked to the tag and rushed to the cash counter. Then she asked the shopkeeper to receive the payment and pack up the dress. So Miss Lovely was there. Who was it, beta? Lovely. She went to the cash counter and she said, I am ready to pay 2000 rupees. Please pack the dress. So shopkeeper refused to hand over the dress to Miss Lovely in consideration of the price stated in the price tag attached to it. Miss Lovely seeks your advice whether she can sue the shopkeeper for the above cause under the Indian Contract Act. 3 marks, beta. This question is asked for how many marks, sir? This question was asked for the 3 marks. November 2008. But first of all, display of the dress is the invitation to offer. Display of dress is the not offer, it is a invitation to offer. Selection of the dress by Lovely is the Lovely selecting the dress, no beta. Selection of the dress by Lovely is the offer, no beta. Shopkeeper is selling, that is acceptance. Shopkeeper is not selling, it is rejection. It is rejection, no beta. So here display of the goods is there by the shopkeeper, that is invitation to offer. Lovely said, I want the dress. That is mere offer. That is only offer. Just offer, mere offer. Offer need not be accepted by the shopkeeper. है ना बेटा? Shopkeeper can say, I don't want to sell the dress. Just because you are not accepting my offer, can I file a case on you, beta? Answer is no. है ना बेटा? So how to answer this question, beta? Step number 1. Provision of the law. Provision of law. Here what we should write, beta? We should write about the invitation to offer. Invitation to offer. Step number 2. Facts of the present case. Facts of present case. So here we should write that Lovely is there. She was approaching the shop, which is approaching the shop to take the dress, which is displayed in the cash counter, and that owner refused to sell the dress. है ना? That was happened. Step number 3. Decision. Since display of the dress mere invitation to offer, selection of the goods is the offer. Offer need not be accepted. So Miss Lovely cannot sue the shopkeeper for the recovery of the dress. She cannot insist the shopkeeper for the dress. है ना बेटा? This is how you have to answer this question, beta. Question was asked in November 2008. So let us see, beta. This question is important. This question was asked so many times also, but not only in November 2008. है ना? So, but wording is important. How to answer this question? So you are getting an idea how to answer, but writing is very important, beta. So step number 1. Provision of the law. Offer should be different from the invitation to offer. So here it is a invitation to offer but not a offer. It is an invitation to offer, है ना. Offer is definite and capable of converting an intention into contract, whereas invitation to offer is only circulation of the offer. It is an attempt to induce the offers. Inviting the offers precedes the definite offer. That means it is not definite specific offer. We are inviting the offers. Displaying the goods means inviting the offers from the customers. That is not a offer, है ना बेटा. Where a party without expressing the final willingness, I never said that I will sell the dress. I am keeping my dress on my display. Propose a certain terms on which he is willing to negotiate. If you give me offer, let us see. I may sell, I may not sell. है ना. Propose a certain terms on which he is willing to negotiate does not make an offer. But inviting only other party here, displaying the goods means inviting the other party. That is lovely here. Lovely, है ना. Shopkeeper, lovely. Here shopkeeper is inviting lovely. Inviting only the other party to make a offer on those terms. I am displaying the price tag. I am displaying this with price tag of 2000. That does not mean that it is a final offer. Give me offer. Will you sell it to me for the less than 2000 or the 2000 rupees? है ना. I am ready to negotiate on the 2000 rupees. है ना. So this is a basic difference between the offer and invitation to offer. Offer is final and definite. Invitation to offer is not final. It is not definite. Here my intention is to decide the offer, invite the offer, है ना. Display of articles with price tag in a self-service shop is merely invitation to offer. It is in no sense offer, no sense an offer for sale. So acceptance of which constitute a contract. So it is not an offer at all. How can you? There is no acceptance, there is no offer, there is no acceptance, there is no contract. Here mere invitation to offer. What is it, beta? Only invitation to offer is there. Next, facts of the present case. A shopkeeper displayed clearly. Here we have discussed what defining what is offer, what is invitation to offer. Offer अलग होता है, invitation to offer भी अलग होता है. Invitation to offer means inviting the offers from the other party. समझ में बेटा? Facts of the present case. A shopkeeper displayed a pair of dress in a showroom and price tag is attached. It is invitation to offer. It is invitation to offer by shopkeeper. By shopkeeper. Miss Lovely looked to the tag and rushed into the cash counter. She asked the shopkeeper to receive the payment and pack the dress. This is offer. This is offer. Shopkeeper refused to hand over the dress to Lovely in consideration of the price tag. This is rejection of the offer. This is offer by Lovely. Offer by Lovely. This is rejection of offer by shopkeeper. Offer is rejected, so there is no binding contract. So how she can demand the dress, beta? Answer: decision. In this case, Lovely, by selecting the dress and approaching the shopkeeper for the payment, simply made an offer to buy the dress selected by her. It is simply an offer. So if shopkeeper does not accept the price, Lovely, interested by Lovely, cannot compel him to sell because offer need not be accepted mandatorily. So we have written what is the meaning of offer, what is the meaning of invitation to offer in step number 1. In step number 2, we have explained what was happened in the question. In step number 3, we are concluding beta. Decision, you will not lose any mark beta. Even he is giving 1 mark, 1 mark and 1 mark also, you will get 3 out of 3. At least 2.5 you will get. Beta. You will not lose any mark. Next heading beta, next question. This question was asked in November 2008. November 2008 for 5 marks. How many marks beta? 5 marks. Direct question. Explain the modes of revocation of offer. Modes of revocation of offer as per the Indian Contract Act. Direct question beta. This is the last topic in our second chapter. So how an offer can be comes to an end? First one by notice of revocation. Notice of revocation. So I gave a offer and I give notice of withdrawing my offer. Offer is comes to an end. Next, by lapse of time. Second one is by lapse of time. I gave a offer on 1st January. 1st January 13. If you want to purchase my car, please give reply by 31st March. Please give reply by 31st March 13. है ना बेटा? Offer comes to an end by 31st March. If it is accepted on 1st April, he become April Fool. But not there is no contract because offer is died on 31st March. When beta 31st March itself it is deceased. समझ में आया बेटा? So by lapse of time, the time for acceptance can be lapse if acceptance is not given within the specified time where there is no time specified. है ना? So we have to accept the offer within the specified time. If no time is specified, no, within the reasonable time you have to accept. Non-fulfillment of the condition preceded pre means before. I'm keeping some condition. If you satisfy that condition, then only I will sell the car. If you're not satisfying the condition specified in the offer, offer comes to an end. On 1st January, I said to Rohit, I'll give you car on 31st March. If you give me advance on 10th January. If you give me advance on 10th January, I give a offer on this date. It must be performed on this date. I said I'll perform on 31st March if you give me advance on 1st January. In 1st January, you are unable to satisfy my condition. So offer is dying on 1st January itself. Non-fulfillment of the condition precedent. Precedent means predetermined, predecided. Predecided. Where the acceptor, as the offeree, fails to fulfill the condition precedent to the acceptance, proposal gets revoked, proposal comes to an end. That is non-fulfillment of the condition. Offer comes to end. Next one is by death or insanity. Insanity means crazy, pagal, pitchy. You know, beta? So death. I gave a offer to Rohit. SG gave a offer to Rohit. Rohit, will you purchase my car for 10 lakhs rupees? You know, beta? Rohit said, yes sir, I want to purchase the car. But before giving up the car, Rohit mar gaya. So when Rohit is deceased, offer also comes to an end because other party is not there to take it, to accept it. Death or insanity of the proposer would result in automatic revocation of the proposal, automatic revocation of the offer, but only if the fact of death or insanity comes to the knowledge of the acceptor as per Indian Contract Act. But as per Indian Contract Act, so offer comes to an end automatically once offerer or offeree is deceased or they become insane. Insane means mentally incapable. Offer comes to an end. Next concept by counter offer. By counter offer, I was asking Rohit, will you purchase pen for 10 rupees? Rohit said, Srinath sir, will you give it for 8 rupees? Offer comes to an end. My offer comes to an end. Next one, non-acceptance of the offer in the prescribed method. I said to Rohit, please give the reply in the speed post. In the speed post, but he gave the reply by the ordinary post. Which post, beta? Ordinary post. Then I said to him, Babu, Rohit, since you are not giving the acceptance in the specified manner, I am not treating it as valid. So offer comes to an end. Next one, subsequent illegality. I entered into agreement with Rohit for sale of the wine. For sale of the wine or liquor. So right now wine is legal, allowed in India. But after entering into contract, Modi uncle said, Prime Minister said, my dear Indians, मेरे प्यारे देशवासियों, मित्रों, आज रात 12 बजे से दारू पीना बंद. So contract become void contract. Void contract. So my offer also comes to an end. है ना बेटा? Next question बेटा, third question. This question is very important. Question was asked 5 to 6 times in the exam, including November 2018. November 2018, Ramaswamy proposed to sell his house to Ramanathan. So Ramaswamy is selling a. This one is important, beta. Listen carefully. When communication ends, this topic related to when communication ends, when communication of offer ends, when communication of acceptance ends, Ramaswamy proposed to sell his house to Ramanathan. Ramaswamy, otherwise Swami. Ramaswamy proposed to sell his house to రంగనాథం, రామనాథన్, రామనాథన్ है बेटा. So he is the offerer, he is the offeree. Listen beta, question is important. Ramanathan sent his acceptance by post. First he is sending a ordinary post beta, sending a ordinary post which contains acceptance, which contains acceptance. Next day Ramanathan sent a telegram withdrawing his acceptance. On 10th 1/21 he sending a ordinary post. Next day 11/1/21 he sending a telegram beta, which is very costly beta. Telegram is very costly and very ordinary things, non important things we will send the ordinary post, very less price and take more time. Not important things, not important things we will send through ordinary post generally, है ना बेटा. Then telegram, very important matters will send through the telegram because very costly beta. 11/21 send a telegram, sending a telegram withdrawing his acceptance, withdrawing his acceptance. Revocation of acceptance or withdrawing of the acceptance, sending 2 letters beta. 10th ordinary post containing acceptance, 11th telegram containing a revocation of acceptance. Examine the validity of the acceptance according to the Indian Contract Act 1872 in the light of the following. First question beta indulo. The telegram of revocation of acceptance received by Swaminathan before acceptance letter. First what is reaching beta? For example, if telegram is first reaching the Swami, then in telegram what is there beta? Revocation of acceptance is there, है ना beta. If telegram reaches first which contains revocation of acceptance, there will be no contract, there will be no contract, khatam, this one is over. Second option, second case, telegram of revocation on letter of acceptance reach together. For example beta, both are reaching him at the same time on the 13/1/21. For example, both ordinary post, both telegram reaching at the same time, then it depends beta. If Swami opens ordinary post first, ordinary post, valid contract will be there, valid contract, because for his mind first what is going beta? Acceptance is going, है ना beta. If Swami opens telegram first, no contract, because revocation is first going into his mind, because revocation is first going into his mind, है ना beta. Clear na? But generally we will assume that first we will open the telegram only first. Generally it is assumed that we open the telegram first. Why? Because telegram contains important things, no beta. So if you are unable to prove anything, court will assume that there is no contract, because generally people will open the telegram first, है ना beta. So let us see the answer. Step number 1, step number 2, step number 3. Important question, sir. Question was asked in November 18 beta. RTP, provision of the law. When communication ends, when communication ends, when communication of offer ends, when communication of acceptance ends, and when revocation ends. Provision of the law. The problem is related with the communication and time of acceptance, communication of acceptance, time of acceptance, and its revocation. As per section 4 of the Indian Contract Act, communication of acceptance is complete against the acceptor, that means offerer, when it comes to the knowledge of the proposer or the offerer. Proposer means offerer, that is Swami. An acceptance may be revoked, that means withdrawn. Revoked means it can be withdrawn at any time before the communication of acceptance is complete against the acceptor, but not thereafter. So, facts of the present case: Swami proposed to sell his house to Ranganathan. Ranganathan sent his acceptance by post. Next, Ranganathan is sending a telegram for withdrawing the acceptance. This was happened in the question. Step number 3. See how I am writing the answer, beta. Case 1, case 2. Case A: if telegram is reaching the first, no, ordinary letter is reaching the first. Telegram. Telegram of revocation of acceptance was received by the Ramaswamy before acceptance letter. That means telegram is reaching the first. Yes, the revocation by Ranganatham is valid. Revocation is valid. Revocation is valid. And no contract. No contract. For example, both are reaching at the same time. If Ramaswamy opens the telegram first, and this would be normally so in case of a normal rational person, है ना, and reads it, the acceptance is revoked. If he opens the letter first and reads it, revocation of acceptance is not possible, so contract will be concluded and binding, है ना बेटा. This how you have to write the answer, बेटा. Step number 3, है ना. Clear ना बेटा. Next question, beta. Question number 4. Question number 4. So let us do the next question, sir. Question number 4. Comment the following statements. Acceptance must be absolute and unqualified, and acceptance must be in the prescribed method, beta. 2 questions are there. He may give for 4 marks. 2 marks plus 2 marks. This question was asked in May 19 RTP, sir. Absolute. What is the meaning of absolute, sir? Absolute means 100%. So, what is absolute, sir? So, what he is saying, beta, acceptance must be absolute. Acceptance must be absolute and unqualified. Absolutely means 100%. Unqualified means without any alteration. Without any alteration. Why? Because altered acceptance is a counter offer, beta. Because altered acceptance is equal to what, sir? Counter offer. Offer must be accepted as it is. For example, beta, mobile worth of 10,000 rupees, pen worth of 100 rupees. I am offering these two things to Rohit for the, for example, 10,100, 100 rupees pen, mobile 10,000 rupees. Rohit can say, yes, sir, I want. Rohit can say, no, sir, I don't want. Rohit cannot say that I want only pen for 100 rupees. It must be accepted as it is. 100%. So, above statement is true statement. So, acceptance must be absolute. Acceptance must be absolute and unqualified. Qualified means variation, better. Unqualified means without any variation, without any change. As per section 7 of the Indian Contract Act, acceptance is valid only when it is absolute and unqualified, and it is also expressed in the some usual and reasonable manner, unless the proposer prescribes the manner in which it must be accepted. If the proposer prescribe the manner of acceptance, it must be accepted only in the prescribed manner. What he is saying, beta? So, if offerer specifies the method of acceptance, specifies the method of acceptance. For example, speed post. So offeree has to communicate acceptance only in the speed post only. If offerer is not specifies the method of acceptance, it can be accepted in any reasonable manner. Which manner, beta? In any reasonable manner. Beta. This second question, beta. Offerer specifies specified manner, not specified in any reasonable manner. See here. So when it is absolute and unqualified, and it is also expressed in some usual and reasonable manner, unless proposer prescribes the manner in which it must be accepted. If the proposer prescribes the manner of acceptance, it must be accepted only in that specified manner. So he gave a small example also here. This question was asked in 2019 May RTP, sir. Clear na beta? Next question. Define the offer. November 19 question beta. Define the term offer. Explain the here definition we have to write beta. Definition, not the meaning. If you read the meaning, you will not get the marks. Definition under section 2a we have to write here. And explain the essentials of a valid offer and how an offer is different from the invitation to offer. If you observe, 3 questions are there. Question number 1, what is offer? Question number 2, essentials of a valid offer. Question number 3, how the offer is different from invitation to offer. If you read any 2 no, you will not get the marks. So if he is given 6 marks no, but each question you will get only 2 marks beta. First, definition of the offer as per 2a. The word proposal or offer. Proposal is as per the English Contract Act beta. Offer is as per the Indian Contract Act. Same but different names. In India we call it as a offer. In England they call it as a proposal. The word proposal or offer are used interchangeably, but both are same. And it is defined in section 2a of the Indian Contract Act as when some person signifies to another his willingness to do or abstain from doing. To do means positive, abstain from doing means negative. To do or abstain from doing anything with a view to obtain the consent of that another to such act or abstinence is said to have made a proposal or the offer. Definition, you will get the 2 marks if you read the definition. Next is asking the essentials of an offer beta. Read only headings, you need not explain because only 2 marks no beta. So 9 essentials are there beta. Essentials of an offer, only headings. Offer must be capable of creating the legal relationship. That means only commercial offers are the offers. Only commercial offers. It must be certain, definite and not vague. That means offer must be clear and it must be communicated. Mere mental determination is not a offer. It must be informed to offering. It must be made with a view to getting the consent of another. I know you will not accept, still I am giving an offer. That is not an offer. Rohit is a pure vegetarian. I am giving an offer to Rohit. Rohit, will you take the chicken for 1 rupee? 1 kg chicken for 1 rupee. It is not an offer because I know he will not eat the chicken. Vegetarian. That is not an offer. It must be made with a view to getting the consent of another. Rohit will die for the chicken. I said, Rohit, will you purchase chicken for 400 rupees? That is the offer. And it may be conditional, but the offer is conditional. Will you purchase the pen for 10 rupees? 10 rupees is the condition. So offer must not contain a term. This one is important, but he will ask in the exam. Specifically, 6th point. The offer must not contain the term non-compliance of which amount to acceptance. This heading he will ask in the exam. That means complaints means following beta. Non-compliance means not following. Offerer cannot say that. Offeree, if it does not give reply, that is deemed to be acceptance. Offerer cannot say that. If offeree does not communicate acceptance, that equals to acceptance. That is deemed to be acceptance. He cannot say like that beta. है ना? Next, offer, it may be general offer or the specific offer. Offer may be expressed or implied. So A statement of price is not a offer. It is invitation to offer. It is an invitation to offer. Just now, statement of price. I'm keeping a dress in the display along with price tag. That is not an offer. Next, difference. Offer from invitation to offer. Important from exam point of view. This question we are saying the second time. Difference between the offer and invitation to offer. The terms of section 2A of the contract. Offer is final expression of willingness by the offerer to be bound by the offer should should be other party choose to accept. It's a final expression. But invitation to offer, it is not a final expression. It is I'm willing to negotiate on the terms. It is not a final offer. It is inviting the offer from you. On other hand, offer is made with the intention to negotiate or offers to receive. I am want to receive the offer from you. So they are known as the invitation to offer. Thus, where a party without expressing his final willingness proposes certain terms on which he is willing to negotiate, does not make the offer but only invites the other party to make the offer. Hence, the only thing that required is the willingness of the person to abide by the terms of the contract. Final expression is offer. It is not a final expression. I want to negotiate furthermore. It is an invitation to offer. समझ में आया बेटा? Next question बेटा, question number 6. This question was asked in November 2019 RTP. A sends an offer to B to sell his second-hand car for 1,40,000 with a condition that if B does not reply within a week, this related to just now I said no beta, this sixth point beta. Question related to sixth point only. A sends an offer to B to sell his second-hand car for 1,40,000 with the condition that if B does not reply within a week, A shall treat the offer as accepted. Is A correct in his proposition? What shall be the position if B communicates his acceptance after 1 week? है ना बेटा? So first of all, offer is not a valid offer बेटा. Acceptance to an offer cannot be implied, cannot be implied merely from the silence of the offeree. If, what does it mean beta? If offeree remain silent, it does not amount to acceptance. Doesn't amount to acceptance. Even if it is expressly stated that expressed in the offer itself, unless offer has by his previous conduct indicated that silence amount to acceptance, so it cannot be taken as a valid acceptance. That means if offeree remains silent, offerer cannot assume that offeree gave the acceptance. समझ में है बेटा? If remain silent, how can I assume that you are giving acceptance? I should not. Silence does not amount to acceptance here. So what was happening in this question beta? A sends an offer to B to sell a second-hand car for 1,40,000 with the condition that condition is invalid here. With the condition that if B does not reply within 1 week, he will treat it as the offer is accepted. So that is not a proper offer at all in the eyes of law. In the given problem, if B remains silent, it does not amount to acceptance. Acceptance must be made within the time prescribed by the offerer. The acceptance of the offer after time prescribed also not valid beta. Is not valid. Not valid. Because he said, what in the question he said, see beta, you have to give the reply within 1 week. Within a 1 week. Time is specified. If you're accepting the reply, if you're accepting the offer after 1 week, the acceptance is invalid. No beta. Acceptance of the offer after time prescribed by the offerer has lapsed will not avail in turn the offer into contract. That means that offer will not be converted into contract if it is accepted after the specified time. He said, I want the reply in 1 week. You're giving reply after 1 week. That is not a valid acceptance. That offer, that acceptance will not convert into contract. समझ में बेटा? Next question, important beta. Good Girl Soap Company. This question was asked in the year November 2008 beta. More than 13 years back. है ना. 2008 question beta, very important question. So this question related to general offer beta. We have seen a famous case law on the general offer in the regular classes. Carlyle versus Carbolic Smoke Ball Company, है ना. This question related to that case law only. Good Girl Soap Company advertised that it would give a reward of 1000 who developed the skin diseases after using Good Girl Soap of the company for certain period as per the print directions. It is a general offer. Which offer beta? General offer. Advertisement is the general offer. Miss Raki purchased the soap, है ना. Purchased the soap advertised in Good Girl. Miss Raki developed a skin disease in spite of using the soap as per the printed instructions. Using the soap as per the printed instructions is the implied acceptance. Is the implied. This is what you have to understand in this question beta. Advertisement is the general offer. You what they said beta, if you use the soap for 5 days you will not get the skin disease, that is the offer. I am using the soap for 5 days, that is the acceptance, है ना beta. So after using the medicine for the 5 days still she has the skin disease. She claimed reward of 1000 rupees. So what she is doing beta, she is filing a case on the particular good girl soap company for claiming of 1000 because they said in the offer use the soap for 5 days you will not get the skin disease. If you're getting now we will give you 1000 rupees. Raki used it, there is acceptance, but still she is having a skin disease, she want to claim 1000 rupees, है ना बेटा. The company refused the reward on the ground that offer was not made to her, and but company saying that I never gave an offer to you, that is the argument of company, and that in case she did not communicate her acceptance to the offer, company saying that I never seen the Raki, I never gave you any offer to her, Raki never came to our company to give acceptance, that is the argument of the company. But court held that Babu, advertisement is the general offer. Using the particular soap for the 5 days as per the instructions is the implied acceptance which need not be communicated expressly. Decide whether Raki can claim the reward or not. Yes, she can claim. Yes, she can claim the reward. Refer the relevant case law also. He is asking you to refer the case law also beta. You should read the case law also. Provision of the law. General offer. Which offer beta? General offer. A general offer is one which is not made to definite person, not given to specific person, not made to specific person, but to the world at large, a public in general. Is general offer. A general offer can be accepted by any person by fulfilling the terms of the offer. It can be accepted by any person. In case of general offer, a contract is made with a person who has the knowledge of the offer, comes forward, acting according to the conditions, acting as per the conditions of the offer is the implied acceptance. Which acceptance beta? That is using the medicine, using the soap as per the directions. Example 5 days. In case of general offer, communication of acceptance is not required because using the soap itself is the deemed acceptance. No, but we need not inform to particular company. In the same step number 1, case law beta, Carlyle versus Carbolic Smoke Ball Company. If you observe the case law also, same thing will be there. Carbolic Smoke Ball Company advertised in the newspaper that it would pay 1000 rupees to anyone who contracts influenza. In the question, skin disease. Here, cold. Influenza is a cold. Contracts influenza after using the smoke ball. Smoke ball is a medicine beta of the company as per the printed instructions. Mrs. Carlyle uses the smoke ball according to the printed directions, but subsequently she contracted with the influenza. Carlyle sued Carbolic Smoke Ball Company for the reward of 1000 rupees. So what was happened in that case beta? Decision on the suit for the reward. It was held. Okay. On the suit for the reward, she was held entitled to recover the 1000 rupees from the Carbolic Smoke Ball Company because she has accepted the offer by fulfilling the terms of the offer, that is using the medicine as per the instructions is a deemed acceptance. So what is happened in the present case, beta? Facts of the present case, Good Girl Soap Company advertised that it would give the reward of 1000 rupees. Who develops the skin disease after using the Good Girl soap of the company for the certain period as per the printed directions. Miss Raki purchased the advertised Good Girl soap and developed the skin disease in spite of the using the soap for the printed instructions. She claimed a reward of 1000 rupees. Company refused to give the reward on the ground that offer was not to made to her and she never gave any acceptance. That was happened in the situation. In the question decision. Miss Raki can claim the reward of 1000 rupees from the Good Girl soap company. If you write like this, you will not lose the marks beta. Out of for minimum 3.5 you will get, because you're informing to examiner what is the law in step number 1. You're informing to examiner what was happened in the step number 2. You're informing to examiner the decision also conclusion. Then why will you lose the marks beta? You will not. Eighth question, self-service system. Same. Invitation to offer. We have seen first question beta. That one, display of the dress in the shop. The same question. Eighth question, first question are same. Questions will repeat beta. Na? Shopkeeper displayed है ना बेटा, the same questions. 8th 7th 8th question also. Next question, 8th question beta, same 2004 question beta, but this is 2004. First question was asked in the year which year beta? First question it was asked in the 2018 November. First question. This question is 2004. That means after 14 years, same question beta. That's why I'm telling you, same questions will come in the exam beta. Do it every day. Shambhu Dayal started self-service system. That means the shop self-service system in his shop. That means it is a supermarket. Srimati Prakash entered into the shop, took a basket. After take self-service system is the invitation to offer. It is a invitation to offer. Mrs. Prakash entered into the shop, took a basket. After taking the articles of her choice into her basket, it is the offer. Offer to Shambhu Dayal. Reaches the cashier for the payment. Cashier refuses. That means Shambhu Dayal not accepting. Shambhu Dayal rejecting the offer. Rejecting offer made by whom beta? Prakash. Srimati Prakash. Srimati Prakash. Refuse to accept the price. Can Shambhu Dayal be compelled to sell the said articles to Srimati Prakash? No. How can we compel the seller to sell the goods? Uska marzi hai. Up to him whether to sell it or not. Step number 1. Provision of the law. Here we have tried the what is offer, what is invitation to offer. We have to explain it here. With a famous case law also there beta for us. Pharmaceutical Society of Great Britain versus Boots Cash Chemist Limited. Quote the case name also, if possible. So offer is different from the invitation to offer. Offer is definite, specific, capable of converting into contract. Offer is capable of converting into contract, whereas invitation to offer is only circulation of an offer. It is an attempt to induce the offers, impress the offers, and precedes the definite offer. It is something before the offer. Pre means before beta. It is situation before the offer. After invitation to offer, offer will come. Where a party, without expressing his final willingness, proposes certain terms on which he is willing to negotiate, does not make an offer. It is only invitation to other party to make the offers on those terms. So this is the basic difference between the offer and invitation to offer. Display of the articles with the price in a service system, merely invitation to offer but not an offer. It is in no sense an offer for sale. So acceptance of which does not any contract. Is it my intention is not to give an offer, inviting the offers from me. That's why I'm displaying the goods on the shop. Famous case law was there on this. Pharmaceutical Society of Great Britain versus Boots Cash Chemist Limited. For this case law also in the exam. Goods were displayed in a shop for sale with price tag. attached to on each article and self-service system was there. It is invitation to offer. Customer selected the goods. It is offer. It was held that display of the goods only invitation to offer and selection of the goods was offer by the customer to buy and the contract was made by when cashier accepting the offer to buy and this is the price, but in the question he is not accepting, that is not a contract. So what was happened? Facts of the present case. Step number 2. Shambhu Dayal started a self-service system in his shop, supermarket. Srimati Prakash entered into shop. She took a basket, taking the articles of her choice into the basket, reaching the cash counter for the payment. But cashier is refusing the offer given by Srimati Prakash. Step number 3. Decision. If shopkeeper does not accept the price, the interested buyer, Srimati Prakash, cannot compel him to sell. Same question again 2013 beta. Ninth question also. See, how many times beta? 2004, 2018, 2013. Same question. In the place of Dayal, he gave D. Remaining same. Mr. D started self-service system, Shambhu Dayal, in his shop. Mr. A in the place of Srimati Prakash, A entered into shop, took a basket. After taking the articles of her choice into basket, reaches the cashier for payments. The cashier refused to accept the price. Can Shambhu Dayal be compelled by the A to sell the said article? No. Same question, beta. Beta, that's why CA Foundation, CA Enter, CA Final. If you do the questions from 1990 or 94, if in my material till 2021 or 2022, pakka you will get the minimum 90 marks out of 100. Same questions will come in the exam beta. I am leaking the ICA question paper also beta. Imagine. Next question beta, 10th question. Explain the general rules relating to acceptance. Is asking the essentials of valid acceptance. Legal rules as to acceptance. So it is the next as per section 7. As per section 7 of the Indian Contract Act, in order to convert the proposal, that is offer, proposal into promise, acceptance must be absolute and unqualified. That means offer must be accepted as it is without any variation, 100%. As per section 7.2 of Indian Contract Act, acceptance of the offer must be in the specified manner. Example, speed post. And acceptance must be signified. That means expressed, specified, indicated. That is, you have to communicate the acceptance. In other words, acceptance is complete only when it is communicated. We're having a case law also on this. That coal mine example, coal mine case law, getting an offer from the Indian Railways. That case law also asked in the exam once. Yes or no, sir? And acceptance is communicated by the offeree himself. Who has to communicate the acceptance beta? Only offeree, but not third party or by person who has the authority to accept. Acceptance must be communicated to offerer, but not to stranger. And acceptance must be given within the specified time. If time is specified, or within the reasonable time. So what is reasonable time? Depending upon the circumstances. Acceptance must be given before it lapses or before it is withdrawn. If it is accepted, in other words, if acceptance is made after it is lapsed, after it is withdrawal of the offer, it will not create any legal relationship. समझ में बेटा? Next, same question beta. When this question was asked, 10th question was asked in the year 2003. So many years back. The same question 2012. Essentials of the valid acceptance. So questions are repeating, no beta? That's why beta do the previous exam questions. Next question beta, question number 12. Validity of the revocation of acceptance. Revocation means withdrawal. Revocation means withdrawal. Taking back. Validity of revocation of acceptance where telegram containing revocation received before. We have discussed second question beta. I think second question same. See, third question. When offer can be revoked, when acceptance can be revoked, the same question beta. This question also, 12th question. Validity of revocation of acceptance where telegram containing the revocation reaches. First, what is reaching beta? Telegram is reaching. Telegram mein what is there? Revocation of acceptance is there. So what is valid? Revocation is valid. Revocation is valid and no contract because revocation is there, beta. Khatam. The same thing. Beta, question number 12 and 13 is equal to question number 3. है ना? So in case of letter of acceptance telegram containing revocation of acceptance are delivered to proposer at the same time. At the same time, the formation of contract depending upon the fact which one is read first by the offerer. है ना बेटा? So if you open telegram first, revocation is valid. The contract shall be said to have been formed if letter of acceptance is read first, but shall not be said to be have been formed if telegram containing revocation is acceptance is read first. If telegram is read first, no beta, there is no valid contract. Generally, it is presumed that a man of ordinary common sense, friends means common sense, will first read the telegram. Hence, revocation is quite effective. What is effective beta? Revocation. Same question beta. 13 and 14, 12 and 13. Simultaneous delivery of the acceptance and telegram containing revocation. Both are same question. 12 and 13. If you observe, same wording also there beta. Same question, same wording. In case of the contract generally it is presumed, है ना बेटा? Same. Question number 3 exactly repeat again. In question number 3 when it was asked beta, question number 3 was asked in the year 2018. Question number 3 in the RTP, है ना बेटा? 14 also exactly same including comma and full stop, May 2006. That means after 12 years repeating the same question beta, May 2006 and 2018, 3rd and 14th beta. That's why I'm telling you, no questions will repeat. Next question beta, 15th question. Let us see. Question was asked in November 2015. Mr. U offered to sell his house to Mr. X for 1,15,000, 15 lakhs. Who is selling beta? U is the seller. X is the buyer. U is selling his building to X for 15 lakhs. How many lakhs beta? 15 lakhs. On the very next day, same question beta. X accept the offer by the post. X is selling the ordinary post which contains the acceptance. On the very next day, X send a telegram revoking the acceptance which reaches you before letter of acceptance. Next day, X is sending the telegram revoking the acceptance. But what is reaching first? It is reaching on the 12, for example, 12/1/2020. It is reaching on 10/1/2020. So first, what is reaching beta? Revocation is reaching first. So what is valid? Revocation will be valid. Same question. So is the revocation of acceptance is valid? Yes, revocation is valid. Valid revocation. Would it make any difference if both are reaching, both letter of acceptance, telegram of revocation reaches the you at the same time? Same question beta. Question number 3, question number 12, 13, 14, 15. Exactly same. Question number 3, 12, 13, 14, 15. Same ditto questions. है ना? So that's why do the previous exam question papers. ठीक है बेटा? I'll explain once again also beta. Provision of the law. Step number 1. In case of letter of acceptance, telegram containing revocation of acceptance delivered to the proposer at the same time, the formation of the contract depends upon the fact which one is first read. First, if he's reading the ordinary letter, contract will be there. Reading the telegram first, no contract will be there. है ना बेटा? Generally will open the telegram only first. The contract shall be said to have been formed if letter of acceptance is read first, but shall not be said to have been formed if telegram containing revocation is acceptance is read first. Generally it is presumed that we will open the telegram only. है ना बेटा? Then question. Next question beta, question number 16. I say practice question. This question was not yet came in the exam, but it may come in the exam beta. So what was happened in this question beta? Gauri Dutt and Lalman Shukla case law is there. Where beta? This case law we have discussed in. When we have discussed beta? So, Gauri Dutt sent his servant Lalman Shukla to trace his missing nephew. Offer must be communicated. Essentials of the offer. He then announced the reward to trace his nephew would be entitled to certain reward. L trace the boy in ignorance of the offer, ignorance of the announcement. Subsequently, when he came to know about the reward, he claimed it. Decide the basis of the Indian contractor whether L is contention is valid, invalid. Beta. Step number 1. Offer must be communicated. Offer must be communicated. है ना बेटा? We have tried the Lalman Shukla versus Gauri Dutt case law also. Lalman Shukla versus Gauri Dutt. Facts of the case. So Gauri Dutt lost his nephew. Gauri Dutt sent his employee Lalman Shukla in search of the nephew. Subsequently, he was announcing the reward, and Lalman Shukla getting the nephew without having the knowledge of the reward decision. Employee is not eligible to get any reward. है ना बेटा? This how you have to answer that question बेटा. Next question. A proposes B to purchase his Android mobile for the 5,000 rupees, and if no reply by him in a week, it would be presumed that B has accepted the proposal. This question we have discussed beta. Question number 6. Exactly question number 6. Question number 6, question number 17, same. That means questions are repeating. Step number 1. Offerer cannot say that if offer is not accepted by the offeree within the specified time, he assumed to have made a acceptance. Question number 6 and 17 are exactly same beta. And this one beta. B, a supplier send a draft agreement relating to supply of the coal to the manager of the railway company with Metropolitan Railway Company. Same case beta. Case name also Metropolitan Railway Company only. Metropolitan Railway Company case. Metropolitan Railway for acceptance. The manager wrote the word approved on the same, but put the draft agreement in the drawer of the table, intending to send it to company solicitor for formal contract to be drawn up. And over the site, the draft agreement was remained in the drawer. What was happening in this case, beta? For example, Rohit is there. Who is there, beta? Rohit is there. He was getting a offer from the Indian Railways. Getting the offer from the railway company. Will you supply coal to us? Will you supply the coal to us? Offer. Rohit wrote an acceptance letter also. Acceptance letter. He has written, but it was not posted to railways. Not posted to railway company. Beta, when you're not posting, it is valid acceptance, beta. It is a perfectly invalid acceptance because writing the acceptance is not important. Communicating the acceptance is important. Step number 1, provision of the law. Acceptance must be communicated. Must be communicated. Case law. Brogdon versus Metropolitan Railway Company. These two things we should read in the step number 1. Step number 2, facts. So here B writing the agreement but not posted to Metropolitan Railway Company. So it is not a valid acceptance. beta next question I say practice question beta. A makes a proposal to B by post to sell his house for 50 lakhs and the letter containing the offer was posted 10th March and letter reaches B on the 12th, but he sends it on the 15th, on which date offer is said to be communicated. Let us see once again beta. A makes a proposal to B. A gave a offer to B to sell his house for 50 lakhs. Till now clear. And the letter containing a offer was posted. Offer was posted on 10th March and it reaches B on the 12th March. 12th March. But he reading it. But B reads it on 15th March. Offer is said to be communicated once offeree getting the knowledge. Getting the knowledge. When B is getting a knowledge of the offer beta, 15th March. है ना बेटा? So offer is complete on the 15th March. है ना बेटा? So step number 1, step number 2, step number 3. Recent question beta, November 2020, define the acceptance and is asking the legal provisions as to valid acceptance. This question also we have discussed previously. है ना बेटा? Clear na? So with this we have done with the second chapter also. Clear na? So please do these question papers again and again. Have a great time. Enjoy the day. Prepare well. SG signing off. Third chapter we will be discussing in the next class.